All right. Is it appropriate at this juncture to make an inquiry and to engage in a colloquy with your client as required by law?
I think this is a good time to do that.
All right. Mr. Sehmer, I'm going to direct my comments and questions to you at this point, sir.
Yes, sir.
I ask you to raise your right hand. Do you swear what you're going to tell me is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Sehmer, I've asked whether or not you will be testifying in the defense portion of this case. Did you hear that question?
Yes, sir.
Your lawyer has told me he does not believe that you will be testifying. Is that correct?
Yes, sir.
Now, you understand the decision as to whether to testify or not testify is a constitutionally protected right. Either way, you have the choice. Do you understand?
Yes, sir.
That choice as to whether to exercise the right to testify or to choose to remain silent and not testify is your choice solely. Do you understand that?
Yes, sir.
In other words, Mr. Shiro, who is an experienced lawyer with many years of practice, while he may provide legal advice to you, is not the decider, cannot be the decider under the law as to whether or not you choose to testify or not. Do you understand?
Yes, sir.
Have you had sufficient time to speak to Mr. Shiro about this subject?
Yes, sir.
And have you reached a conclusion or decision as to whether or not you're going to testify or not in this case?
Yes, sir.
And what is that decision?
I will not testify.
All right. Has anyone threatened you in any way or promised you anything of value to reach that decision?
No, sir.
And you reach that decision freely, voluntarily, and intelligently?
Yes, sir.
Do you have any questions about your right to choose to testify or not testify for Mr. Shiro as we speak right now?
No, sir.
Mr. Shiro, have you had enough time to speak to your client?
Yes, sir.
And do you believe he's freely, intelligently, voluntarily waiving his right to testify in this case?
I do, sir.
Court will find that Mr. Sehmer is freely, intelligently, voluntarily choosing to not testify in this case. I will accept his waiver of that right, and we will proceed to trial, bringing the jury in. Before we do that, is there anything the state feels I need to address?
No, Your Honor.
Anything the defense feels?
No, Your Honor.
All right. Kim, you can ask him to bring him down, please. For the benefit of the parties, to bring the jury in, we'll go through the witness that Mr. Shiro has described as a brief witness. At that time, I'll ask of the state whether there are any rebuttal witnesses. Assuming there are not any, I will release the jury back to the jury room for probably 15 or 20 minutes before we would proceed to opening statements. This court's practice in opening statements is, closing statements, thank you, is to have the parties engage in that process before jury instruction. I will be providing instruction at the end of closings. Is 15 or 20 minutes as a break sufficient for the state
Yes, sir.
and for the defense?
Yes, sir.
All right, thank you. You'll change that packet. Okay, you want to print out your long. Molly. from this morning that one of the 14 jurors was unable to appear today due to a family emergency, which the court has accepted. And the court has inquired with the parties, and all parties have agreed with the court that that juror would be deemed as one of the alternates in the case, leaving 13 individuals in the jury box with one alternate yet to be recognized. So I wanted to explain to you why your number is one less today than what it was yesterday. The trial is proceeding, and we are at the stage still with the state. I'll make some inquiries this morning, and then we will proceed accordingly. Ms. Opper, does the state have any additional witnesses?
No, Your Honor, at this time the state rests.
All right, thank you. The state rests. That would transfer the case to the defense. Mr. Shiro, do you have any witnesses this morning?
I have one brief witness, Your Honor.
All right, and are you prepared to call that witness?
I am.
All right, why don't you go ahead and do that?
I'll go grab it.
Who is it, sir?
It's a police officer, and I'll have to spell his last.
Okay, that's fine, sir. Officer, if you'd come forward. There's a witness box behind the court reporter. If you would make your way there, sir. Step up there and raise your hand. Do you swear that the testimony you're about to provide is the truth, the whole truth, nothing but the truth, so help you God? See. That black bar with the red light, keep your voice directed there and your voice up, all right, sir? All right, counsel.
Thank you. Sir, would you please state and spell your last name?
Last name is Maciejewski, Maciejeweski, first is Scott,
And sir, how are you employed?
with the Village of Heartland Police Department,
How long have you been so employed?
23 years.
Okay, always with that department?
Yes,
Okay. And how long, was that the only law enforcement position? Oh, that seems long.
yes,
Okay. Did you have an opportunity as part of your duties to interview some witnesses regarding an incident on June 17th of 2023?
yes,
Okay. Did you have a chance to take a statement from a Mr. John Laporte?
I did.
Okay. Do you remember when you did that?
It was sometime in the morning.
Okay. If I showed you your report, would that help refresh your recollection?
Yes,
If I may approach.
You may.
Showing only grade 108. Could you take a look at that for a minute, please? Okay. Can you tell the jury how it was that you had this interview with Mr. Laporte?
it was a telephone interview.
And did you have some information that you had received that indicated he might have some information?
Yes,
Okay. Can you tell me what Mr. Laporte indicated or told you was what he was doing that night, the 17th?
he was,
Object as to hearsay.
This witness has testified. Is this being offered? How is this being offered, counsel?
For the truth of the matter asserted, Your Honor, under section 908.03 sub 8. It's a statement from a officer involved in an investigation, and I believe the statute makes it not hearsay by definition.
Counsel approach. All right, I believe the defense is going to rephrase the questions here.
Okay. So we understand who we're speaking of. You spoke to a Mr. John Laporte, is that correct?
Correct.
And you had discerned some information to indicate that he may have seen something that was relevant to the case, is that correct?
That's correct.
And did Mr. Laporte indicate to you that Mr. Laporte, had seen of the two people, the one with the shorter man with the long hair, possibly pick up a stool and possibly walk in the direction of the larger gentleman? Did he say that?
Correct. He said it
And
was
then he
possible.
said, John wasn't too positive about the stool because everything happened so fast. Is that what he told you?
Correct.
Okay, I have nothing further.
Any cross?
And Mr. Laporte also gave a written statement to your knowledge, right?
Correct.
That wasn't to you, that was to a different officer, is that right?
That's correct.
And in this statement about the stool, he wasn't sure about the younger male with the stool.
That's correct.
And you also went and spoke with the owners of Tabby's and getting video surveillance and things like that, correct?
I spoke to the owners of Tabby's on the phone.
Okay, who are the owners of Tabby's?
Mind if I?
Is your report still up there?
Yeah.
If your report refreshes your recollection, that's fine, but read it to yourself. And then I'll ask the question again.
Okay. Okay.
Who are the owners of Tabby's Wine Bar?
Sean and Tabitha McBride.
Not Mr. Sehmer.
Correct.
I don't have anything further, Your Honor.
Any redirect?
No, thank you.
All right, officer, may this witness be released?
He may, Judge, and I'm moving 108 into evidence.
Um,
That portion of it that we just read.
Before he leaves then, do you want to have him identify 108, please?
Yes, I.
No, just ask him the question.
Is that your report, 108?
Yes.
That involves the interview with Mr. Laporte?
Correct. Phone interview.
It's a single page.
Yes.
What page of your report is it?
It's page 15 of 22.
Thank you. You're moving 108. Any objection?
No, Your Honor.
108 will be received into evidence.
Thank you.
May this officer be released. Any objection from the state?
No, Your Honor.
All right, you can go about the rest of your day. Thank you.
Thank you.
We have it from May. Thank you. Yes, with that, we will.
Thank you. Just so it's clear, Mr. Shiro was not on the microphone. Mr. Shiro, do you have any additional witnesses?
No, sir.
Does the defense rest?
We do.
Thank you. All exhibits have been offered and received as offered by the state, correct?
Correct.
And all exhibits have been offered and received as offered by the defense.
Yes, sir. Just take 108.
That's fine. You can provide that to my clerk. Ladies and gentlemen, I'm going to release you just for a few minutes, probably about 20, to allow the parties to, in the courtroom to be prepared for closing statements and then instruction. Oh, I missed one part. Does the state have any rebuttal witnesses?
No rebuttal, sir.
Thank you. I was expecting you would not, so I didn't say it out loud. I said it in my head. So with that, then I'll release you. Please do not discuss this case. We'll have you back here in about 20 minutes. We'll begin closing arguments, and then I will provide instruction and provide you with the information for purposes of your deliberations. All rise. All right, please be seated. It is 8:57. I'd like the parties to be back at 9:20 for purposes of beginning closings. If you have any technology needs, please test it in the interim. Is there anything from the state before we break?
No, sir.
Anything from the defense?
Judge, I will move to dismiss at the close of the whole case. I will do so without argument right now, since
All
we
right,
just had this,
right.
although the standard has changed.
It has, but the court's conclusion is the same. The motion to dismiss at the close of the case, while it doesn't require the court to view evidence in the light most favorable to the non-moving party of the state and consider the totality of the evidence, still believes there is a sufficient factual record for purposes of creating a factual issue from which a finder of fact needs to reach conclusion. One, did your client cause the death of Josh Davies while committing aggravated battery with intent to cause bodily harm under section 940.19 subsection 4? There are two elements to felony murder, and there are two elements to aggravated battery under that statutory section. And the court believes the factual record creates factual questions as to the elements in this case. There has been argument that Mr. Davies was struck. Strike that. There had been testimony that Mr. Davies was struck sufficiently hard. This is the medical examiner to cause acceleration of his physical body into the concrete outside of this establishment in Heartland, causing him to suffer a skull fracture and a subdural hematoma, which ultimately caused his death. There has been testimony by the medical examiner that under a medical standard equated to homicide. Again, the factual issue that the jury must grapple with is whether the legal standard for homicide, felony murder, has been established. But the court believes there is an abundance of facts here, while the defense has vociferously argued and will argue undoubtedly at closing that this was a circumstance where the defendant was required to defend himself. I still believe strongly that the facts established in the record could be read another way. Therefore, the court believes that the matter is appropriately resolved as a factual matter by the jury. The court will deny the motion. Is there anything else from the defense?
Judge, there is. We had a jury instruction conference last night.
Oh, yes, we should put that on the record.
Yes.
Go
please.
ahead.
Judge, with respect to the substantive instruction, I know that the court has included both retreat and provocation. I believe that neither is justified. I believe that particularly with regard to provocation, it is my belief that the evidence suggests that whatever dispute had happened inside Tabby's had ended. And in fact, the evidence showed that my client was speaking with Mrs. Davies and Ms. Burke in a friendly manner, and that this argument had ended until such time as Joshua Davies came back to the bar and yelled some profanities about why his wife is still talking to my client described in a profane manner. Therefore, I don't think provocation is appropriate.
Thank you. The state have any comment?
Your Honor, that's one view. I know that's been expressed by Attorney Shero in his opening statements and somewhat of a theme of his, but we have an entirely different view of that, in that the situation certainly was not over at that point. And the law doesn't require that. The law doesn't require a break, so to speak, in order to claim or for the provocation instruction to be appropriate. Even if we ignore everything that happens inside the bar. Outside the bar, we have clear video showing the defendant advancing on the victim who was backpedaling. That's provocation right there. So these instructions are legally appropriate.
Thank you. The court did engage in this discussion during the jury instruction conference. It's really been largely repeated here. The court has chosen to include the optional instructions. I think it's under 811 and 815.
I think it's 8:10.
810 and 815, thank you, of the form jury instruction. The focus here is on the provocation instruction. I understand the defense's argument and the effort of the defense to try to create separation from what can best be described as boorish behavior. That's really by the defense's own argument of the defendant directed towards the victim in this case while in the bar. But I don't believe that the jury has to accept separation in time. And really, if there's a basis for them to think this was a continuing moment, while there may have been some physical separation between the parties, briefly, the jury doesn't have to conclude that was over. Clearly, in some degree, they could conclude it was not, the way that your client, based upon the video, kind of launched himself through the front door. So the court believes, and also I agree with the state, that separation in time is not required. You can have a provocation instruction with a single continuous event with no argument that there's some sort of time separation between moments. If the defendant is, if there is a potential that a defendant has provoked the circumstance, the court believes that language would be appropriate. So the court believes that there is at least a basis for the jury to consider both the issue of retreat and provocation as contained in 810 and 815, and I've included the language over the objection of the defense. I think that was the only objection, those two. Was that correct, Mr. Sherrill?
That is, Judge.
All right. And so other than that, are the jury instructions acceptable to the defense?
Yes, sir.
And the verdicts have been handed out, and are those verdicts also acceptable?
Yes.
Verdicts have been discussed and will be handed out. The state have any objection to the jury instructions as presented?
No objection, but I just want to clarify that I see 315 is in the packet. I don't know if the defense specifically requested it. Defendant elects not to testify. It's on page 12.
Oh, thank you. That was included by my clerk, but I did not ask. So let me ask, Mr. Sherrill.
Yes,
that is an optional choice of the defense.
I would like it, and I see that it's in there, and I'm asking that it stay there.
Stay there. All right. Thank you for addressing that, Ms. Hopper. Other than that, the state has no objection?
No objection, Your Honor.
And as to the verdicts that were discussed, the state is in agreement?
Yes.
All right. So now it's 9:06. I'll see you back here at 9:25. All right?
Thank you.
And you want to come get one of that? Statements, the jury is prepared to come into the courtroom. Does the state have anything for the record?
No, Your Honor.
Defense?
No, sir.
All right, the alternate will be selected after closing, but before instruction. Kim, you want to tell him to come in, please?
All right.
Do it. Yes, I am. All right, please be seated, everyone. Ladies and gentlemen, we are at the point of closing arguments from the attorneys. The first closing argument will be given by the state.
I don't know if I need it, but. All right, well, good morning, everybody. Thank you very much for your service in this trial. I'm glad we were able to wrap it up a little bit quicker. Got it now?
Yeah, I think it's on. Tap it.
Testing, testing.
I can hear you, so that sort of tells me it's on. Go ahead.
Or I speak loudly, yes. So again, thank you very much for your diligence in paying attention to this trial and the facts. I know the testimony wasn't always the easiest. First of all, it could be emotional at times, but second of all, I'll be the first one to stand up here and tell you, we have 4 different people seeing 4 different things at 4 different times, right? That's human life, right? We've all experienced this. This isn't a Hollywood movie script where they're gonna come in and perfectly match, because they're seeing different things. They're viewing things from different viewpoints, right? And let's not forget the violent attack that they had just witnessed and the trauma and the shock that their brains were undergoing at the time they're witnessing this and then trying to recall it. And of course, there's been some passage of time. It's been about a year. So all of that leads to this situation we have here where we have different versions of events. But the question is, are they credible? Did you believe these 4 people who came in and told you about what they remembered and how this played out to the best of their, right? And same with the videos. You know, I surely wish we had a better quality video outside on the sidewalk, but we don't. So we presented to you the best that we have, and we presented a couple different versions that the crime lab was able to enhance. Whether you find those useful or not is entirely up to you to decide. But we're not relying on just one witness or one video, right? It's the whole entire series of events and the recollection of the witnesses. For you, ask you to piece together, can you clearly make a determination here as to what happened? Okay. So I'm very grateful that you were patient and paid attention, because you're going to have your work cut out for you. I'm not going to stand here and say this is an easy case. This is an open and shut case, and you know, should you take you 10 minutes to deliberate? I would never say that. And certainly on a record like this, where you have a lot of different viewpoints and a lot of different information to consider. So I appreciate that you're willing to do that work, and we're grateful for your service here. I want to start out by just talking a little bit about the events that that we have been discussing here for the last 2 days. And I'm going to start where we ended actually with our case, and that is the words of Kevin Sehmer, right? The question still remains why any of this happened. We still have never found an answer to that. No one was able to tell you why Mr. Sehmer was so upset about the choice of Josh Davies to tattoo his body. What difference does it make to Kevin Sehmer? We have no idea. But seemingly that was the underlying cause of this entire incident, is that immediately upon seeing Joshua Davies, he took exception to his appearance. He told Detective Hoffa in his interview that he didn't like him from the start. And I think that's readily apparent from the video inside Tabby's wine bar, that immediately upon meeting Josh, he's making derogatory comments to him. You're a sinner. You've marked up God's work. You're going to hell. That's not a friendly interaction between 2 people who have just met out on a Saturday night trying to enjoy a really very common activity that we all participate in. Hey, it's summer, finally, it's June 17th. Let's get outside, let's go to a band, let's have a couple beers, let's enjoy our friends, right? And to walk into that bar trying to meet up with Laura and meet Mr. Sehmer for the first time, what the heck happened? Well, he ran into Kevin Sehmer. That's what the heck happened to Josh. So Kevin Sehmer gives an interview to Detective Hoffa. I'm going to play a little clip of it for you. I'm not going to play the whole thing. This is, I'm sorry, can you turn on?
So this clip that I'm gonna play right now is from State's Exhibit 24.
And I lost my cool, and I say I lost my cool. So I just, what did you say? And then I went outside. The girls tried to, say, yeah, just, drunk, and I'm like, well, so, and I swear to you on my dad's grave, on my kid's life, I went outside and his friend and this guy had stools in their hands, and
So a guy and the guy and his friend had stools?
yeah, they're up in the air like this,
Okay.
and I said, what did you say? And then, now, like, oh, now you're gonna hit me with a stool. I'm not saying this, but I'm thinking,
Right.
oh, I'm gonna get knocked in there, with a stool.
Okay.
And 2 stools. So, but so the one friend, he tried to hit me with a stool first, and I don't know really what happened, but all I did is block it, and that was it. And I didn't touch him. I didn't say anything to him. Nothing.
Okay.
Then the other guy, the husband, he comes in. He's really, and he winds up and he's gonna not, and I don't know what the hell happened with me if I had like some almost it was like second part or something. I just held my hand there and I just pushed him that with the stool in his hand and I just pushed him away.
Okay.
He fell over onto the ground and then I left.
Okay.
So let's unpack that a little bit. There are multiple lies or falsehoods stated by Mr. Sehmer in that statement when he's being questioned by Detective Hoffa. It's not in this clip, but remember he started out by claiming both guys were drunk. They were pretty intoxicated, he said. Well, the record's quite clear. Brian Richardson had 1 beer the whole night. You can see Brian in the video. He is not impaired. He's not intoxicated. But Mr. Sehmer wants to make it seem that way because that's to his benefit, right? I got attacked by 2 drunk guys. So he embellishes, he lies, he misdirects, whatever word you want to use. He's not being truthful with Detective Hoffa. Then he says, I walk outside and both guys have a stool above their head. 2 stools. He doubles down on it. He goes back to that later. 2 stools I'm confronted with. That never happened, ladies and gentlemen. Not one witness, not one piece of videotape shows Brian Richardson with a stool in his hand ever. But he's got to say that, right? Because that makes it better for him. Well, I had no choice. I had to go after these guys. 2 of them came after me, and they both had stools. So he's got to make that up. Then he says, Brian tried to hit me. Brian never tried to hit Mr. Sehmer. Nobody saw that. That's nowhere in any video. Then he says, the husband, Josh, he came in and he really winds up. Those are his exact words. He really winds up. And I was able to just push him away. And he fell down and I left. Nobody, not one witness on that sidewalk saw Josh making a motion like this. Not one. It's not in the video anywhere. Now you can say, well, maybe it happened back closer to the tabby's door and it's not on the video. John LaPorte would have seen it. Brian Richardson would have seen it. Jen Davies would have seen it. His own wife came here, courageously told you those events that night. And she told you, yeah, I did see Josh with the stool and he had it up here. Never did she describe swinging motion. Nobody did. It didn't happen. He's got to tell these stories so that it looks good for him. Well, I had no choice. I had to punch him or push him, as he would say. Nobody has Josh swinging a stool. In fact, I'm going to play another excerpt for you. Desktop here. No. Thank you. I just lost my cursor here. You can? There it is. Okay, thank you. This is Exhibit 8. This is the video from Hometown Pharmacy. This is the original version, not anything changed by the crime lab. Close out. I just can't see it here. Okay. See, we do test these things and I still have user error. Can you go to settings?
There you go.
Okay. Sorry, I just need to duplicate my screen.
It's
now.
fine.
Okay. All right. I apologize, folks. So as I said, this is Exhibit 8. This is the original clip from Hometown Pharmacy, not enhanced in any way.
Right now we have a,
Yeah, I mean, when I started.
okay, I
Thank
was
you.
worried about the traffic call.
Thank you. I started it at the beginning. And I paused it at 12 seconds. Through the door of Hometown Pharmacy, you can now see Josh Davies standing there. I'm going to click it ahead one frame, 13 seconds. Watch his right arm as I click through these frames. His right arm is down at his side right here in this frame. 14 seconds, still down by his side. 15 seconds, still down by his side. Now he makes a step to the right with his feet. And there you can see at 15 seconds, a motion like this with his right arm from his hip area up, right? He is not doing this. He is not doing this. His arm is down near his waist at all times, right before the blow gets delivered by Kevin Sehmer. I'll continue playing. I had paused it at 12, 13, 14, and 15. I'm starting again at 15. There he goes. And there's the follow through from Kevin Sehmer. 100% inconsistent with what he told Detective Hoffa. He claims he's the guy making this motion. I just went like this and blocked the stool. He did not. That's follow through, folks, from a right hook. He stepped through it. You see his body turn. That is a solid punch to Joshua Davies' head. That's what that is. He did not make the motion Josh Davies made of that. He's stamped over. You see his body physically turn. That's the force of the punch. Nobody saw Josh Davies swinging a stool out. It did not happen. Mr. Sehmer, in his interview with Detective Hoffa, is trying to make himself look good. He's trying to justify his actions. He's telling her misinformation, falsehoods, because he wants to say, 2 guys started swinging stools at me and I had no choice but to hit one of them. Now, another thing that was suggested during the opening statement of Attorney Shiro was that, well, there really wasn't a battery at all. We think Josh just tripped on the stool and fell on his own. Nowhere in the video do you see that. No eyewitness described that. They were all asked. Jen was asked. Brian was asked. John was asked. Did you see Kevin trip over anything? No, I did not. I saw Kevin Sehmer punch him in the head, and then he dropped to the ground like a house of cards. That's what I saw. He didn't trip. There's no evidence he tripped over the stool. None whatsoever. And in fact, that is directly contradicted by the testimony of our medical examiner, Dr. Bidzicki. I've only known the woman 30 years. Bidzicki. Remember how she described the level of force, the acceleration that would have had to have occurred in order for Josh to have the injuries that he did. That is not consistent with the trip, she said, because there would not have been enough acceleration from a simple trip or a stumble. I asked her, how much force do you think would have to be involved for injuries like this to be obtained? And she said, quite a significant amount of force. Quite significant. Remember, she described the hemorrhaging in the brain that was so deep. She said it's actually pretty unusual to see that level of injury that deep in the brain because of the sheer force. Remember, she was using that term, the velocity, the shearing force when that head hit the ground. Sadly, because Josh was unconscious and couldn't brace himself in any way, fell down. John Laporte described the detail, and I'm sorry because I know this sounds really cold, but he saw Josh's head bounce off the sidewalk. That's exactly what Dr. B said. Remember how she described the injuries in the front of the brain from the brain hitting the skull in the front? Her testimony absolutely. And the event as we know it unfolded is that Kevin Sehmer forcefully, violently smashed Josh Davies in the head and caused his injury and ultimately his death. Interestingly, not even Kevin Sehmer told Detective Hoffa that Josh tripped on the stool. So that was new information in the trial. Even Mr. Sehmer never suggested that. He admitted that he pushed Mr. Davies forcefully, and that's what caused him to fall. I'm now going to play a clip from Exhibit 26, in which he expressly.
Period. So I'm going like this, trying to, and I think he's going like this and trying to hit me, and he's doing, as he's doing that, I luckily got a good, with the open hand, I got a good grip of the, and I didn't grip it, but I mean, I got a good spot on the stool where I just if you want to use the word violently, that's kind of unfair, but I would say, yes, I pushed him down with one open hand, and he immediately went down to the ground, and I didn't say nothing to anybody else. I turned around and I walked away. That was it.
So not even Kevin Sehmer claims this was just a trick or a stumble because Josh was so inebriated, he had lost all of his motor skills. Remember that? By the defense, they brought in Dr. Henson to try and tell you that he had lost his gross motor skills, his fine motor skills, and he was so intoxicated that he couldn't even defend himself. Attorney Zillaby asked him that. Well, if he's this intoxicated, then he wouldn't have an ability to defend himself from a sudden attack, right? And Dr. Henson admitted that. There's no evidence, and you can see the Tabby's video, that Josh Davies was unable to comprehend what was going on around him, that he was stumbling, that his balance was impaired, that he could not function properly, right? Hey, I get it, folks. A 0.24, yeah, I'm not here to tell you he was stone sober. I'm just here to say it did not have the impact on him that you may expect. You just hear a number. You don't know anything about it. You don't know how much he had to eat. You don't know what his tolerance is. So look at the video with your own two eyes and tell me, was he grossly impaired by his level of intoxication? If so, where is it in the video? In fact, what we see in the video that I just played for you, number 8, is him walking backwards very adequately, right? Backpedaling 5, 6 steps, whatever it is. Is that somebody who is grossly impaired? He's not grossly impaired. He's got a 0.24 BAC. He is not grossly impaired. You cannot reach that conclusion based on this record. Nobody said it. Nobody. The people that are with him that night, and the video speaks for itself. Absolutely not. This incident is not attributed to Josh's level of intoxication. It's attributed to the actions of Kevin Sehmer. Had Kevin Sehmer not punched him in the head and knocked him out and caused him to fall to the ground and hit his head, he would not be dead. It's just that simple. That's why Kevin Sehmer is charged with felony murder, because he engaged in a felony, that is aggravated battery. He punched Josh in the head. Aggravated battery. And when Josh fell to the ground and hit his head, that's what led to his death. It's his actions, his conduct that caused Josh's death. No other conclusion can be reached on this record. I have an opportunity to speak to you again in rebuttal because it's my burden of proof. And in fact, as Mr. Sehmer has claimed self-defense, I have to overcome that and prove to you this case was not self-defense. So I'm going to reserve some of my comments for my rebuttal closing. There's other things I want to talk to you about, but I think they will be more helpful to you in the context of understanding the defense position that this was self-defense. Thank you.
The next closing statement will be given by the defense.
Oh. Me? Now? The state has spent a lot of time trying to make this homicide case about an argument where my client was acting boorishly and inappropriate. I think I told you in the beginning, I didn't think you would find that his behavior was okay inside Tabby's. It wasn't. But this case isn't about bad behavior inside this bar. It's not. Mr. Davies was never injured inside Tabby's. There are really two issues. They're complicated, factually, but there's really two issues. First, not complicated. Did Mr. Sehmer batter, punch Mr. Davies? That's one issue. If you determine that my client didn't batter him, didn't punch him, then that's it. Then it's not guilty. As simple as that. I think that's what happened here. And I think that's what the evidence shows. But let's just kind of break it down so that you can understand, because it's a little complicated. The second issue is, well, if we thought he battered Mr. Davies, was he acting in self-defense? That is, was he doing whatever he did because he was being assaulted by Mr. Davies? I indicated initially, that is in the opening statement, that this was an argument that had already ended. Now, I'm not asking, nor should I ask, that you not consider the fact that my client had been acting badly in the bar. I mean, that's obviously evidence in the case. It's, however, as I again would state, that's not where Mr. Davies was hurt. So they had, that is, Mr. Sehmer and the two women were talking, okay? I doubt they particularly liked Mr. Sehmer, although they did both stay there, and they were talking. It wasn't a long time. At some point, my client, gives a hug to Ms. Burke, but whatever, and they were standing together, the two women. And if Mr. Davies doesn't come in the bar and start screaming to Mr. Sehmer and to his wife, are you still talking that blah, blah, blah? There's no event. And there isn't. So while it doesn't mean that what my client had done previously doesn't matter, but it is like, well, okay, the facts of this case are that it really had kind of stopped. It didn't make him not a bore in his behavior, but it was over. And then Mr. Davies came back in. I think, based upon the evidence, is that he didn't like the fact that his wife was still talking to him. I mean, I kind of get it. It makes kind of sense. He's probably thinking, why are you talking to that jerk? I mean, he was just rude to me. So I get that. I mean, I do. I'm not critical of Mr. Davies. I'm not. I mean, I get it. He was mad at that point, and probably more mad at his wife. But he was mad. And then when my client hears this, my client then goes out of the bar. And the two women try to stop him. It doesn't quite work. He gets upset. And they try to get him out. I mean, they try to get him to not go out because he had been angry already once. Okay? But then what happens? Okay? Now, you're going to see, this is what Ms. Burke wrote that night about what happened. And you remember, she was, she didn't go outside like Ms. Davies did. She says, from inside, I saw through the window that Josh had a chair raised above his head. Now, this is not Mr. Sehmer saying this. Okay? Let's be clear about this. This is not Mr. Sehmer's statement.
This is Miss Burke's statement, a longtime friend of Miss Davies and a friend of Josh's. She is the one who says that night he had a chair raised above his head to hit Kevin as he approached. That's her statement, not Mr. Sehmer's. I think I overheard someone say he has a chair or he's going to hit him with the chair. Again, this is Miss Davies and Josh's friend. That's what she saw that night, not Mr. Sehmer. She saw it that night. Now, Miss Davies, she says that her husband picked up a chair or a stool to defend himself. And she's, not very happy with Mr. Sehmer at this point. And she says, the man who I know as Kevin ran after him screaming at my husband about God and tattoos. My husband defended himself and picked up a chair or a stool to defend himself from this crazy person who went after him for no reason. Okay. Well, what does that mean? Well, it is that night, and I do understand that she was upset. Okay. This was, in fact, traumatic for her. Her husband was now in a hospital while that is, medical professionals are doing things to help him. She has an opportunity to write this statement out. Now, and I understand that people, when they're upset, maybe they're not as clear as we'd like. But what's disturbing is that what she should have been upset about, if her current story is true, that is, if she believed, based upon what she saw, that Mr. Sehmer punched her husband, causing him to go to the ground. Is it reasonable? Is it in our life experience that you would exclude the single most important fact of this incident? This thing that has put your husband in the hospital, that you would not include what it is that she now says is the reason he was in that hospital, the punch. Now, with all due respect to Mrs. Davies, this is a difficult circumstance. I get that. But when I asked her about why she didn't include it, she seemed to suggest that, I thought we were all going home. That's kind of what she said. That's really not unreasonable. Not only is it not reasonable, it's kind of ridiculous. It is impossible to believe that that's the excuse that you didn't write. He punched my husband. Had she really seen him, my client, punch her husband and has him go to the ground, it would be the single most important thing she wanted to make certain that law enforcement knew. He punched him, but she didn't. She went part of the way and said that he picked up a stool to defend himself, which is like what Ms. Burke said. The two women there both said the same thing. He picked up this stool. And I think Ms. Davies says he had it up here by his head. Ms. Burke said it over his head. I don't know that it really matters, okay? But if we take, for example, Ms. Davies' statement, it's here by, kind of above his shoulders. And she also, having acknowledged that he did that, she also in her statement doesn't say that he chucked, I think was her word, I hope that's right, but something like he chucked the stool at Mr. Sehmer. Now, again, just as it is difficult to understand or find credible that you would do this, you would write this statement and not include that he, Mr. Sehmer, punched it. It's also difficult to understand how you're actually writing about the fact that he had this stool to defend himself and not say, well, how did he do that? It is kind of an interesting absence, okay? Now we have I'm not including that he was punched, even though I'd seen it supposedly, but I'm not going to include what he did with the stool or chair. Everybody thinks it's a metal stool. So instead, she waits till the trial, not in her statement, to say, well, he just chucked it. Well, you would have said that night. Yeah, he had a chair, but he just threw it on the ground or threw it towards him, but didn't do anything. I mean, she says to defend himself. Well, okay, how? Now, it doesn't matter that she doesn't have all the details, but the two important details are, one, say that your husband was punched by my client, and two, and what he did with the stool that he was defending himself with. So those two witnesses, state seems to suggest, tell the same story, and they kind of do. The story, though, is that Mr. Davies had a stool and used it to defend himself. And in fact, somebody even screamed, he's going to hit him. I mean, that's what they said that night. That's what they said that night. It's a different story now, but I get that. But the government has to prove this case. And I'm sorry, it's a bit odd to suggest, well, I know this is really complicated. And I mean, they're all telling different stories. As if in our system, you can convict somebody of a crime, a serious crime, even though, well, nobody really knows what happened. They don't really know because they all saw things and they're all different things. And yeah, that's okay. Well, is it? Is it okay that they can't tell a story that makes any sense? Some of it is just simply not sensible. But that's what the state is asking us. Now, the other thing that's a little odd is that Ms. Davies, again, I'm not trying to be mean to her, she says that she was actually right with my client. I mean, with her husband. I mean, she was right next to him. Now, you're going to see these videos because I'm going to play them because they really kind of matter. What you're not going to see is Jennifer Davies anywhere near there. I mean, nowhere near her husband. I mean, she's just not there. Now, one of the witnesses says, well, she never came out, but she's not there, okay? Which is a little odd because given what you're going to see and already have seen in these videos, you're going to see that Josh does kind of launch himself. I mean, if you look at it slowly, you can see he literally is launching himself. And he then, something happens and he goes down. Now, the state can say, yeah, there's the follow through of a punch that we can't actually see. I don't know. I don't know how much counsel knows about boxing, but it's not like that. So she was right there. Presumably, if she were right there, you remember how we see he just goes down. She'd be right there. And there are reasons that we would think, one, she wasn't there, and two, if she was, we'd have seen her. But she wasn't. So the videos, and we're going to play them, and I'm not going to play just one, and I'm not going to play the first one. We're going to use the enhanced slowed one, okay? Because I want to show you some stuff, okay? And I think it would be fair to say that any of us who have been dealing with this, and now you folks, have to deal with these videos, and they are hard, okay? They're hard. They're hard because you're looking at various different things. You're trying to look and see where maybe somebody's legs are, where somebody's hands are, where their head is, where they are, where they're moving. But I just want to show you these videos because you really need to see these. And with all due respect, the prosecutors claim that, oh, and this shows it all. Well, it does, but it doesn't show the battery that you're saying. That isn't what we're going to see. You can pretend you're seeing it, but you're not. So let's just take a look at it, if I may. Okay? And I apologize. You're probably sick of seeing these, but they are important. Okay? And without seeing them, it's hard to judge this. All right. Now this is the enhanced. Okay, they made it better, make it easier for us to see. And then we're going to play that. And then I'm going to play it where it's slowed. Okay? So you get to see the same thing, but you're going to see it first fast, real time, and then halftime. Okay? So,
Judge, I'm sorry to interrupt, but can you please tell us what exhibit numbers you're displaying?
what number?
This is exhibit 12.
Exhibit 12.
Thank you.
Thank you. Now, what we just saw was a couple of things. And I don't expect you to see everything you've seen, but we've seen a couple of things. We clearly see Josh moving backwards, right? I mean, there's no question about that. And then he does seem to move a little bit to his right. And then we see him kind of launch himself. Can you back this up? Have this back this up? See how it looks like he's going up, and it does appear, and I can't tell you I'm sure, okay, I'm not. It does appear that both his legs seem to leave the ground. And then the next thing is, shortly after that, he is falling kind of to his right and down. Now, I'm gonna have her play the next one, which is what number?
Exhibit 13.
Number 13. This is the half speed. Thank you. Okay, so again, it's hard because even slowed, it's still a little complicated. And obviously looking through these windows, we know isn't perfect. I mean, it's just not perfect. So, but again, it does appear that, well, one thing that's utterly clear is that this isn't Josh standing there and getting punched. This is Josh moving. I'm using the word launching because his legs seem to get off the ground. Now, I'm going to tell you why I think he did that in a moment, but that's what the videos show, okay? Now, of all the witnesses that had some information, all but Mr. Richardson says that Josh had a stool at some point. Obviously, both Mrs. Davies and Ms. Berg are very clear that, yeah, he had it. They hear people yelling that he's got a chair. Mr. Richardson said, no, he never had a chair. Now, he has had some issues in the past, and you are able and can consider that incredibility. But it doesn't, you don't get to say, well, you know, I still want you to consider his testimony. You believe him, even though what he's saying is different than everybody else. We can't do that. We can't ask you to plug this into make you computers and say, all right, what does all this mean? Well, the state has to prove this case. It's not just like, oh, just figure it out, but it's all okay. Well, it's not okay if you're trying to prove that my client committed this crime, because it's not what they're saying he did. Now, Mr. Laporte originally said that possibly Joshua had a stool or a chair, I think a stool. But later he said, no, that didn't happen. It's a little odd because you would expect him even to say, well, I wasn't sure, but now I'm sure he didn't have it. But in any event, his testimony is kind of not helpful to anyone, quite frankly, because he puts this whole event half a block away. And if that were true, there wouldn't be any activity over here. He'd be way to the left of this. I mean, it just didn't happen. I don't know why he recalls things the way he does and why he claims he saw what he saw. But it's so out of the range of anybody else's version of what happened. And it is utterly refuted by this video. Whatever Josh and Mr. Sehmer are doing, it's not a half a block the other way. I mean, it's right there. So I don't know what we can say about his testimony other than it doesn't support the state's burden of proof in establishing guilt. Now, do you remember when Mr. Armstrong talked about absolute difference? It's a little, let's look at absolute difference. What he said, I mean, this is the dark one, the two dark videos, okay? What he says that objects that are darker, that are stationary, and they get lighter if they're in motion, okay? It's weird. I don't completely understand it, but that's what he said it does. So I want to show you these for a minute. There's two, okay? And I'm going to show them to you. They're in different speeds. There's a regular speed and the partial speed, okay?
This
So-
is exhibit 14.
Thank you.
Go ahead, keep going. Okay, now, one thing that's pretty clear already, just even in full speed, is that this is where Mrs. Sehmer said she was, and there's nobody there. And if she had been there, she would have had to have been moving around here. She would have been very clearly a moving object, moving person, okay? She's not there. That's relevant because it's kind of an odd thing to be so wrong about it when she was there. She just wasn't there. Right, now I gotta clear this. Right? Now we're gonna play it slow. Right? What number is this, please?
This is exhibit 15.
All right, I want you to tap. Go back. Right, there.
Starting from 4 seconds.
4 seconds. Stop. Back it up.
I'll do it.
Back it up. Tap, tap, tap. Stop.
Mhm.
Stop. You didn't have this. Stop there, please. Okay. Don't run it at their speed.
Mhm.
Okay?
Okay. Would you like me to slow down?
Yes.
Perfect.
But you gotta back it up.
Stop. This. See that? That's it's now lighter because it's moving. Something has just moved, quite frankly, right at his feet. And there's something else that we see. Okay. You see how there's light there? We went from it being kind of dark. I mean, and it's all moving, but that is a moving object. That's why it looks lighter. That is the stool. Can I be 100% certain? I'm not going to tell you that. All I know is that Mr. Armstrong told us that's how this works. That if something is moving, it is lighter than something that is just stationary. And we've now seen two things. We saw this thing. We've seen that thing kind of come down. It looks kind of towards Josh's feet. And up here is something, now this lighter thing is here. Now, go ahead and let's play it this way. I think I have to clear this. Thank you. We have now seen two things from absolute difference. That's what they call it, so that's what it is. And what it is showing us, two very significant facts. This is the government's evidence. This is the government's expert brought this in. And what we've now seen are two really important facts that I think are somewhat irrefutable. One, something has come at his feet, and two, as he's lunging, as I've called it, we see movement. We see this lighter, whatever they call it, which is something that happens when something's in motion. And what's in motion here is not, as counsel says, him raising his hand. No, it's him with the stool in the position, quite frankly, that his wife had put in his hands earlier. Remember when he said he was like this? And what Ms. Burke says, he had it over his head. Now, of course, he can move, but the notion when she said it was like at this is exactly what we just saw. That's what we saw. Thank you. So the videos do show that, one, Mr. Davies lunged at him. Two, that Mr. Davies had something in his hand, and it's the stool. Now, I'm not going to claim that I know everything about this absolute difference, but I know what he told me. And what he told me makes it clear that what my client said is accurate. Now, I understand that the state claims, well, this is all Mr. Sehmer's fault. Well, he did get in an argument with him. He did act like kind of a jerk. I get that. And then Mr. Davies comes back in and starts, yells at him and reignites this thing. I wish my client hadn't left, but it's not a crime to leave the bar and yell at somebody who just called you a name. But it's not a crime to do that either. Okay? Now, I have to differ
with the prosecutor's belief that the medical examiner and Dr. Henson both essentially say, well, it doesn't matter. He was, he really wasn't drunk. I can tell you, I think without fear of contradiction, that no prosecutor in the state of Wisconsin has ever told a jury that a person with a 0.24 blood alcohol level was not impaired. That has never happened, probably in the history of Wisconsin jurisprudence. Nobody would say such a thing. It's laughable. It's quite frankly ridiculous, and it's just a bit offensive considering my client's on trial. That, oh, well, 2-4. I mean, he's got a tolerance. We saw him. Well, yeah, we did see him, but it's a video, and two, we don't really hear him say anything other than yelling some profanity. I don't know. I can't say exactly how it affects him, but I know nobody in law enforcement in this state or this country thinks that somebody with that much alcohol is not impaired and is not with less faculties. Now, why does this matter? It's not to make him seem like a bad guy. I don't care if anybody gets drunk and driving. What difference does it make? But in this case, his effort to try to hit my client with the stool is made more complicated because when Mr. Sehmer blocks it forcefully, he doesn't have the ability to right the ship that he's just started down the path. He's up, his feet are kind of off the ground, he's trying to hit somebody, and that person forcefully resists that. Now, we did talk a little bit about the fact that everybody tolerates things differently, okay, and that's true. But there's a certain level of which, and I think Dr. Henson made it pretty clear that, well, at some point, everybody's impaired. Now, the other thing that's interesting is the medical examiner, she had an opportunity to see all the records, had the opportunity to do the autopsy. What she never said, never provided any testimony about, was that there was any injury to the side of Josh's face. Now, the state is arguing that there was this unbelievably hard smash to his face, but not one bit of medical testimony or evidence suggested that Josh had any injuries, not any bruising, nothing regarding this, not a bit. So you can say, well, it was really it must have been a hard punch because he hit his head so hard. Well, she then suggested and agreed that, well, of course, if somebody is, pushing and somebody pushes back hard, the law of momentum, the law of motion, okay? You can throw yourself down if you're doing this and somebody's going this backwards. And it appears Mr. Sehmer, being quite a bit heavier, would be in a position to exert far more force than the lighter Joshua. Now, it is pretty hard to argue that my client hit Mr. Davies so hard that he did all this damage, and despite a plethora of medical people, medical personnel, nurses, doctors, and the medical examiner had all these records, and nowhere in there does she say, or did she find, that there was some evidence of any injury to his face. Now, given the degree of force that they're claiming my client exerted on his face, not on a stool that he was holding, that's hard to understand. Now, in Mr. Sehmer's interview, he wasn't utterly candid about everything. I mean, I think, but what the state didn't remind you of is that when he initially said there were two people with the stool, that later in that line, that in the interview, he said, yeah, you're right. I acknowledge it. It was just Josh. It wasn't two people. So when he first said it, all right, he said it. I don't know why he said it. May have been he was trying to protect himself. It may have been that given the circumstance of these two people, I don't know. I can't speculate. But you can't act as if he didn't say that, correct it. I mean, he did. He said, no. I agree. It was just Josh. It wasn't both of them with the stool or with chairs. So I don't know, other than the fact that what he said is utterly consistent with absolute difference, I don't know what else he could say. Now, as I indicated earlier, there's really two issues. One, did he commit a battery? Nobody, I don't think, is arguing that a person, whether they claim you provoked it or not, that you're allowed, once you provoke something, you're allowed to get hit in the face with a stool and you're supposed to just take it. You can't put your hand up. You provoked this, so you're going to get what's coming to you. That's not the law. Okay? Now, the issue of provocation is interesting. You know, it's a judgment you'll have to make. Okay? I mean, whether the initial argument where my client wasn't behaving badly, I think is enough to say, well, that's provocation. He doesn't get self-defense. I think most people would hate to think that if I misbehave, 10 minutes later, if somebody, calls me a name and I go want to talk to them about it, even if I'm moving fast, that, well, too bad. You're going to get anything you have. If they want to, hit you with a baseball bat, too bad. You were a jerk, so you get to hit in the head. I mean, but is it really a battery? I mean, is that reasonable? First of all, is it a battery to block a punch? Is it a battery to stop a stool that's being swung at your head? According to the state, that's not a battery. Or that is a battery, I guess. I don't know. I mean, not because they have to prove that he intended to harm him. That's what a battery is. You caused harm and you intended to. Is it intending to cause harm when somebody tries to hit you with a stool and you block it? That's not intending to harm. That's just stopping something, even if you go like this. Now, the second issue is, again, so if you say, well, that's not a battery, then the case is over. And did they prove that it was a battery? And remember, as the state acknowledged, they have to disprove self-defense. It's not like I have to prove self-defense. Once this has become an issue, which it clearly is in this case, okay, the state has to prove beyond a reasonable doubt that he wasn't acting in self-defense. And I think it's hard to say if somebody hits you with a stool, you can't block it. So, but it's their burden of proof. But I'd like to talk to you about the burden of proof for a minute. The judge is going to give you the instruction. Okay, there's a couple important factors. One, the defendant is entitled to every reasonable doubt, if there's one. Okay, that is there a reasonable doubt as to what happened? Now, I alluded to this earlier. If the state's witnesses cannot tell the same story, it doesn't mean you can't convict somebody, but it's hard to say, well, I don't have a reasonable doubt about what happened here when I don't get same stories, or where stories change, where locations change. He starts with the presumption of innocence and it remains. And it only stops if after you reviewed everything, you conclude that, well, no, he did this beyond a reasonable doubt. Now, one of the parts of the jury instruction says that if you can reconcile the evidence on any reasonable hypothesis consistent with his innocence, you must find him not guilty. You're not given a choice. If you say, well, we've considered this evidence, and there is evidence here that seems to suggest, and it's reasonable, that he didn't punch him, that all he did was block this, that's a reasonable hypothesis. Now, is it the only hypothesis? No, but if it's a reasonable hypothesis, and we know that absolute difference makes it a reasonable hypothesis, it's the actual truth, that Josh was swinging something. Now, the issue of this tripping, I have indicated, and I believe, that there are really three principal things that caused this. One is that he had left his feet and he was swinging a stool, which was blocked. Smaller force met larger force pushed it away, and he fell. The second is that he was intoxicated, grossly so. Now, again, it's not a judgment on him, but it does make it harder for him to do what he's trying to do physically, and it caused him to go down. And lastly, that there does appear, I don't know if you want to call it a trip or what you want to call it, but absolute zero showed that something came right at his feet, just as about the time he's about to, launch. I don't know if that's a trip or if that's just another factor, but those are factors that caused him, I think, in part to go down. But the principle is he's trying to swing a stool, and my client blocks it, and in his intoxicated state, he fell. One of the things that the jury instruction says is that we should consider these things, like what is a reasonable doubt, okay? And it's complicated, but, I think they do a pretty good job of explaining it. One of the ways they explain it, because they try to do it in a number of ways, one of the ways is this a kind of doubt that would give you pause or hesitation in acting in the affairs of life, okay? And, lawyers both on the state or on the defense or civil litigation, they all kind of can talk about this a bit, not in civil litigation, and they say, what are the kinds of things that we consider that are important in life? And would you not pause before you made such a decision? I've heard examples of if your child needed surgery and the judge and the doctors are saying, well, there's this and there's that, you could do this process, you could do this, or maybe you don't do that. And some people say, well, that's something that's an important affair of life. And would this cause you to say, well, I'm going to pause and hesitate before I make that decision? No, that's completely fair, but it does kind of illustrate how important this is. I mean, it really is important. And that is, before I say guilty, before we say guilty, I need not to have those doubts. I can look, I will examine it all critically, but at the end of the day, you can't say that I'm not in a position where I'm like, whoa, I'm really pausing on this. I don't know how you get there. How do we get to, he did this? And I don't think the state did that. I don't think the state can do that. And when you hear the state keep saying, well, there's this problem, that problem, and it's, it's a long time ago, and, I'm sorry, my client's trial is today, and I understand it happened a year ago, but they have to prove beyond a reasonable doubt that he did this. And we don't get to just say he was a jerking tabbies, and don't worry that they can't, keep their stories consistent with the state's theory. You have to say no. There's both a reasonable hypothesis consistent with his innocence, and there are many, many reasons to doubt. And I think there are many reasons to doubt, and I'd ask that you find him not guilty. Thank you.
Any rebuttal from the state?
Yes, sir, thank you. So, ladies and gentlemen, I guess I'll just start by talking about some of the things Attorney Shiro just shared with you.
he put up the absolute difference videos, 14 and 15. And he had his paralegal clicking through and showing you, and then he paused it on a certain time. I don't know what the time was, but he paused it at a certain time and he circled two areas, one up by Josh's head and one at his feet. And he claimed both of those objects were the stool. So I have no idea what he's talking about. He said, look down here. This is the stool at his feet. And then he said, look at this object up here. And he circled that one. That's the stool. That's Josh swinging the stool. I don't know. I don't know who had the stool, where the stool was, who picked it up first. John Laporte was very clear. Said Kevin Sehmer walked out of the bar, grabbed the stool, and threw it in the direction of Josh. And then I walked out to the curb in the street and picked it up later. Uncontroverted. He never even asked him about it again. There's a stool in here somewhere, ladies and gentlemen. Really doesn't matter. You don't have to sit here in your deliberations and figure out exactly who had the stool, when, and where. You don't, because Mr. Shiro was flat out wrong on one thing. He told you, I can provoke a fight and still claim self-defense. He said that. That is not the law, ladies and gentlemen. Judge Domino will tell you what the law is after we get done with our comments. It is very plain. He will read this sentence to you. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense. You provoke an attack, you don't get to claim self-defense. So if there is self-defense in this case, you know whose part it's on? Josh's. Josh is using reasonable self-defense. Did he pick up the stool after Kevin threw it at him? Hold it up to try and keep this raging bull away from him? Maybe he did. That would be reasonable self-defense on Josh's part, if he did. You're not going to be asked who picked up the stool, who threw the stool, where did the stool land. You're going to be asked, is he guilty of causing Josh's death? Did he batter him? Aggravated battery in a way that caused his death? That's your question, ladies and gentlemen. There is no doubt, Kevin Sehmer provoked this entire incident. Give me 1 second, I'm going to ask you to put up my table. It is up. Okay, thank you. Thank you. Put up number 11. The video from inside Tabby's. We're going to talk about this. This is the one enhanced by the crime lab where they turned up the volume. So hopefully it's loud enough. Starting at 0.
I'm gonna get more. What's the name right here? What was that one? It's like her, right? Yeah. That's right.
Okay.
just remember, listen.
Pausing it at 47 seconds. Joshua Davis just walked away. Just walked away. Kevin Sehmer verbally attacks him the minute he meets him. Why do you have those tattoos? You're going to hell. You're a sinner. Joshua Davis walks away. First attempt by Josh to cool down the situation.
I would give that to Eddie. Fuck you.
Stopping at 103. Aggressive act number 1 by Kevin Sehmer. F you, pointing directly at Josh Davies. Provocation.
Okay.
109. Go outside and practice falling down. I'll be right out there. He has just told you, ladies and gentlemen, in that statement, his intent is to get Josh Davies on the ground. And he's inviting him to fight. I'll be right out. Go right ahead out. I'll be right there. Fighting words from Kevin Sehmer. Aggressive act number 2.
There. Yeah, motherfucker, let's go.
112. Come on, MF. Let's go as he marches over to Josh's position. Look at the reaction of Laura Burke. What the heck is going on? Aggressive act number 3 from Kevin Sehmer, right there. Approaches him. What does Josh do?
Shut your fucking mouth.
Josh says, no, stop it. He's not bait. He's not taking the bait. He's not engaging. He's backing down. He is standing down, saying, stop it. No. He never moves a muscle. He looks over his shoulder. He didn't turn around and confront him. He doesn't point at him. He doesn't curse at him. He says, stop it. Is it over now? Nope. Because then Mr. Sehmer says, shut your effing mouth. Aggressive act number 4.
Trying to keyword. Try it. Yes, if you die, that was the place you need to. Little girls, little parents.
Stopped at 132. Aggressive act number 5, 6. Calls him a girl, a Karen. I don't even know what that means. Brian couldn't tell us, but he thought it was insulting. Fighting words from Kevin Sehmer. Josh does not respond in kind. Josh stays in his position at his table away from Kevin Sehmer.
Like I said, once they're falling down, right out there.
Again, my intention, Kevin Sehmer says, is to put you on the ground. Go out there and start practicing. I'll be right out. Provocation. Both of you. Now he's the tough guy. He's going to take on both Brian and Josh. He ain't afraid of that. Both of you go out there. I'll be right out.
Yeah, this is Kevin is not bullshit.
Aggressive act 9. Kevin doesn't put up with bullshit pointing at Josh. Josh does nothing. Talking to his wife, agrees with his wife. It's not worth it. I'm going to go outside and wait. Yeah. 202, in fact, he leaves. That's it. Josh walks away. never uses fighting words, never confronts Kevin Sehmer in kind. Now, Attorney Sherrill will tell you, well, that's it. It was over. No reason for Josh to come back in now. That was the end of the dispute. But it wasn't. Absolutely not. Josh is outside now. Next thing we hear from Kevin Sehmer,
It's a pussy.
fighting words. Is he cooled down? Is it over? Josh is outside. Is he cooled down? Does Kevin Sehmer think it's over at this point? Now watch Laura Burke. She got 2 drinks in her hand. She told you, I took his drink and I was trying to lead him out the back door because I wanted to separate him. I wanted to get him either on the back patio or back over to Beer Snobs to his friends. So she's got 2 drinks in her hands. Watch what Kevin Sehmer does.
I know.
Takes the drink and plants it back on the table. Is it over? Is it over? He's not going anywhere. Real easy for him, if it's over in his mind, to just walk out that back door, go back and pick up his buddy Tom, or go back and have a drink with Laura on the back patio. It's not over. It's not over by any means.
I needed a piece. Maybe that jerk's related. I've known John forever. 20 years. This guy. 20 years. Yeah, that's such a lot. I love John. I got it. So maybe you're taking. I'm certain I'm.
250. Josh is back in the door. Look at his feet. He never even crosses the threshold. So for people to claim he came back into the bar is really an overstatement because he never enters the bar. He opens the door and he says to his wife, "Are you still talking to that asshole?" Well, can you blame Josh for saying that at that point? Can you really blame him? What he doesn't do is he doesn't threaten Mr. Sehmer. He doesn't call him any names. He doesn't use any fighting words. He doesn't go further than the threshold. He doesn't charge in, knock over 2 women, and get in Kevin's face and say, F you. He opens the door and says to his wife, "Are you still talking to that ex?" What is Kevin Sehmer's reaction to this?
What did you say?
Is it over? Is it over? Laura Burke's got him by the arm. Stop. No, no. Jen's in front of him, trying to block him. Jen, 5'2", petite woman. Kevin Sehmer, 6'2", 275 pounds. It's not over, folks. It's not over for Kevin Sehmer. He's going to go out there and he's going to make sure Josh practices falling down for sure. No, 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 no. From Jen. Stop. Stop. This doesn't have to go any further. It does for Kevin Sehmer. What does he do? Pushes her aside and storms out the door. Now, he would have you believe that at this point, he gets outside and 2 guys are out there with stools, right? That's his original version to Detective Hoffa. I walk outside and there's 2 guys, all armed with stools, all revved up and ready to go. Well, then, Mr. Sehmer, wouldn't you just turn around and walk back into the bar where you just came from? For safety? Why would you go out there in the first place?
Why even go out there in the first place? But if you did, and you walked out there and there's two guys with stools over their head, wouldn't you just turn around and go back inside if you're not looking for a fight? Kevin Sehmer's looking for a fight. Kevin Sehmer thinks he's a tough guy. He thinks Josh is a little girl. This is provocation, folks. Provocation from start to finish. Charging out that door after Josh. You saw the hometown video. Josh is backing up, trying to get away from this raging bull. And he keeps going. He's afraid. He's afraid for his safety. Why keep going, Mr. Sehmer? Turn around and go back in the bar. Absolutely no explanation for his behavior other than he wanted to hurt Josh. He didn't like him from the start. He didn't like his tattoos. And he's going to be the one to finish this, right? He's not going out the back door with Laura, not returning to his friends. In fact, he ran. He goes up to Josh, punches him in the head, and runs. Leaves his friend behind at the band and gets the heck out of there. And when the cops go to his house at 5 a.m. to talk to him, doesn't come to the door. How drunk was Kevin Sehmer? Well, be nice to know. If he hadn't run, police could have talked to him, gauged his level of impairment, maybe asked him to take a breath test. Who knows? We know Laura Burke said he was drinking all night. Every time she saw him, he had a drink in his hand, and he was drinking vodka. Cops knock on the door at 5 a.m. He doesn't answer, so can't view him then. It's not till about 1 o'clock in the afternoon that he finally shows up at the police department and they can get eyes on him. Well, that's 12, 14 hours later. Kevin Sehmer's the one who's acting like he's impaired. He's belligerent, he's difficult, he's argumentative, and he's right. No matter what anybody says, he's going to get the last word. He's right. This was not self-defense by Kevin Sehmer by any stretch. This is a man looking for trouble. I don't know why. It's absurd. Laura Burke said he was perfectly fine at the band. When I met him out at Beer Snobs, he was a nice guy. We got along. All of a sudden, what switched in his brain? I don't know. But I do know he attacked Josh Davies outside that bar for no reason whatsoever. I know that he punched him in the head, causing him to fall down with such force that it damaged the inner core of his brain. That's not tripping over a stool. At the end of the day, ladies and gentlemen, you don't have to figure out why he did it. I don't have to prove a motive. I can't. I can't prove a motive to you. What was that button? Oh, you're in your phone. Go ahead. This is the last picture they took, Jen Davies said. There they are at the street party. Man lost his life over what? Don't know. But I do know Kevin Sehmer is to blame for it. Kevin Sehmer is responsible for his actions that night. Kevin Sehmer is responsible for Josh's death. There's no question from Brian, who was there, Jen, who was there, and John, who was there. Kevin Sehmer punched him in the head and caused significant, great bodily harm to him and ultimately death. That's an aggravated battery, ladies and gentlemen. And the fact that death resulted makes it felony murder. Asking you to return a verdict of guilty. Thank you.
Members of the jury, the court will now instruct you on the principles of law that you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply the law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law given to you by these instructions, and from these alone, be guided by your soundest reason and best judgment in reaching your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard the impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges that the defendant, on or about Saturday, June 17, 2023, at 111 East Capitol Drive in the village of Heartland, Waukesha County, Wisconsin, did cause the death of Joshua Davies while committing aggravated battery with intent to cause bodily harm. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Felony murder, as defined in Section 940.03 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being while committing the crime of aggravated battery with intent to cause bodily harm. Before you may find the defendant guilty of felony murder, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following elements were present. First, the defendant committed the crime of aggravated battery with intent to cause bodily harm. Second, the death of Joshua Davies was caused by the commission of aggravated battery with intent to cause bodily harm. The first element of felony murder requires the defendant committed the crime of aggravated battery with intent to cause bodily harm. Aggravated battery with intent to cause bodily harm, as defined in Section 940.19, subsection 4 of the Criminal Code of Wisconsin, is committed by one who causes great bodily harm to another by an act done with intent to cause bodily harm to that person or another. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, the defendant caused great bodily harm to Joshua Davies. Cause means the defendant's act was a substantial factor in producing the great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death, or which causes serious permanent disfigurement, or which causes a permanent or protracted loss of impairment of the function of any bodily member or organ, or other serious bodily injury, is great bodily harm. Second, the defendant intended to cause bodily harm to Joshua Davies. Bodily harm means physical pain, injury, illness, or the impairment of physical condition. Intent to cause bodily harm means the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. The intent to cause bodily harm must exist at the time of the act causing great bodily harm. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. The second element of felony murder requires that the death of Joshua Davies was caused by the commission of aggravated battery with intent to cause bodily harm. Cause means that the commission of the aggravated battery with intent to cause bodily harm was a substantial factor in producing the death. Self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person. The defendant believed that the amount of force that the defendant used or threatened to use was necessary to prevent or terminate the interference, and the defendant's beliefs were reasonable. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. There is no duty to retreat. However, in determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against the attack. The state must prove by evidence that satisfies you beyond a reasonable doubt that the defendant did not lawfully act in self-defense. If you are satisfied beyond a reasonable doubt that the defendant committed the crime of aggravated battery with intent to cause bodily harm, and that the death of Joshua Davies was caused by the commission of aggravated battery with intent to cause bodily harm, you should find the defendant guilty of felony murder. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with reason and prudence and judgment. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising out of a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against a defendant charged in the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside of the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent is not to be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all other evidence in determining how much weight, if any, the statement deserves. Remarks of the attorneys are not evidence. If a remark suggested certain facts, not in evidence, disregard the suggestion. An exhibit becomes evidence only when it is received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any questions that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain evidence might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend upon the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of the jury to scrutinize and weigh the testimony of the witnesses and determine the effect of the evidence as a whole. You are the judges, the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In determination of credibility, you must avoid bias, conscious or unconscious, based upon a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend to either to support or discredit the testimony. Then give to the testimony of each witness the weight that you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with a specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion or opinions, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which the opinion is. Strike that, I'll say that again. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Evidence has been received that one of the witnesses in this trial has been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. Now, members of the jury, the duties of counsel and the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. The consequences, any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following two forms of verdict will be submitted to you for your consideration concerning the charges against the defendant, Kevin Sehmer. 1, reading, we, the jury, find the defendant, Kevin Sehmer, guilty of felony murder, aggravated battery with intent to cause bodily harm, as charged in the information. Another reading, we, the jury, find the defendant, Kevin Sehmer, not guilty of felony murder, aggravated battery with intent to cause bodily harm, as charged in the information. It is for you to determine which of these forms of verdicts submitted to you. I'll say that again. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. And I or a clerk may inquire of you if you agree with the verdict. There's one other piece of business before I charge the jury and dismiss you. The court has requested a random selection of one juror name of the 13 jurors remaining on this jury to reach a number of 12 jurors that will be considering this case for deliberation. The alternate that has been selected by randomly go with Tom. And if you want to provide your contact number, I'm sure that the clerk will contact you after regarding the results of this trial. I want to thank you for your attendance and your work in this case. Go ahead, Tom. We'll wait just a minute until Tom returns. I would ask the clerk to swear the officer.
Do you swear that you will keep all verdict on this trial together in some private, convenient place, and that you will not allow any person to speak to them or to speak yourself except whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do. Ladies and gentlemen, it has come time for you to deliberate on this case. I'll ask you to retire to the jury room. I'll warn you that the next time you come into court, it may not be this courtroom. This courtroom is being commanded for the afternoon for another matter. So don't be disrupted by that potential. Please follow Tom and he'll direct us to the location of your deliberations. I wish you good.
All right.
Please be seated. For the benefit of the parties and anyone spectating, the courtroom to which the court will be assigned this afternoon is 3129 on the third floor. It is currently 11:38, and I expect this courtroom will be under deconstruction and reconstruction. And so it's likely that the next convening, whether it's for questions of the jury or for receipt of a verdict, will be in that courtroom. That courtroom is not the size of this courtroom. It's significantly smaller. This is the large capacity courtroom. We have a number of individuals that are present in the gallery. There will not be seating for the number of people that we have here in this courtroom. So I want to make that you aware of that, and also the district attorney to be communicating with its victim witness coordinator to make sure that issue can be addressed appropriately. I've also provided lunch menus for the jury given the hour, so I expect that they will order lunch, and my expectation of that is that the verdict will likely be after lunch, but I've been right and wrong as to those predictions in the past. So I would ask that you provide your contact information, your cell numbers to my clerk, and that you remain within 5 minutes of this facility, which for everyone means on this campus, until we conclude this matter. Is there anything else from the state that the state feels I need to address before we stand in recess?
Nothing, thank you, Judge.
Anything else from the defense?
No, Judge, thank you.
All right, that's it. We'll have to clear the courtroom at this time, please. the defendant is present. I've been informed that the jury has reached a verdict. Before I bring the jury in, and the jury is ready to come in, I'm going to observe, first of all, that this is a case, obviously, where there is understandably high emotion. But I will tell you that this is neither a sporting event nor an opportunity to express oneself. If I have any sense of disruption by any person, I will not hesitate to clear this courtroom with the assistance of the Sheriff's Department that is present. I do not want to hear any audible reaction or response to this process. This process commands respect, and that is exactly what I expect. If you have not yet, please turn off your phones. All right, Madam Bailiff, could you direct the jury in, please?
All rise.
Please be seated. Ms. Wolf, are you the jury foreperson?
Yes, sir.
Has the jury reached a verdict?
Yes, we have.
I'd ask that you hand that verdict to the bailiff, please. Court is going to ask the clerk to read the verdict.
We, the jury, find the defendant guilty of felony murder, aggravated battery with the intent to cause bodily harm as set forth in count 1 of the information.
Is there any request to poll the jury?
No, Your Honor.